Let's start with what might be your biggest asset, your home. Whether you own one home or several, a vacation cabin, or even a little patch of land you hope to pass down. The way your property is titled, where it's located, and who's connected to it all matter more than most people realize. Today, we'll look at how to make sure your property, your piece of the world, is handled exactly how you want it to be. Real estate is often the cornerstone of someone's estate plan. It can also be the biggest source of confusion later if it isn't planned carefully. Maybe you've heard of people going through probate in 2 states, once where they lived, and again where they had a vacation home. Or families surprised to find out that adding a child's name to a deed caused tax problems, or worse, gave that child's creditors access to the home. These situations happen every day, not because someone did something wrong, but because no one explained how property ownership actually works. The good news is, with a few clear choices, you can make things smoother for everyone who comes after you. Part 1. Where you live, also known as your domicile. Let's start with what seems like a simple question. Where do you live? It sounds obvious, but legally, it matters more than you might think. If you split time between 2 states, maybe summers in Michigan and winters in Florida, only one of those is considered your domicile, or your true legal home. That's the state that will guide your probate process when you pass. Your domicile is usually where you spend the most time, vote, register your car, or file taxes. But it can get complicated if you move around a lot or own multiple homes. If you're unsure which state counts as your domicile, that's a great question to bring up when you meet with your accountant, financial advisor, or an attorney later. For now, just note where you think it is. That'll help guide your future decisions. Part 2. Ancillary probate. Now let's talk about something that creates a source of surprise for several estates. Ancillary probate. If you own property in more than one state, say a condo in Arizona and a main home in Oregon, your estate could have to go through 2 separate probate processes, one in each state. That means extra paperwork, extra time, and often extra expense for your loved ones. The fix? With a little planning, you can often avoid that second probate entirely. For example, you could place property in a revocable living trust, which allows it to transfer directly to your beneficiaries without going through the court process. Some states also allow transfer on death deeds, which automatically pass the property to your chosen person when you die. The key takeaway: if you own real estate in more than one state, make a note of it now. It's an important piece to handle intentionally. Then there's a discussion about community property states. If you're married and you've lived in or currently live in a community property state, that can also shape how real estate is handled. In those states, property acquired during the marriage generally belongs to both spouses equally, even if only one name is on the deed. That can be helpful in some cases, but it can also cause confusion if one spouse tries to leave a property separately through a will or trust. You don't need to memorize the rules. Just be aware that where you live and when you bought your property can change how it's treated. Which brings us to ownership, types and risks. Let's look at how your property is owned. If your home or other real estate is titled jointly with right of survivorship, it automatically goes to the other owner when one of you passes. That can make things simple, but it also limits your flexibility to leave your share to someone else. If it's owned as tenants in common, each person's share can be left separately through a will or trust, which can be useful if you co-own a rental property or vacation home with siblings. Now, here's an important caution. Sometimes, people add their adult children to the title of their home thinking it'll make things easier. It can actually make things harder. If that child has financial trouble, say creditors, divorce, or bankruptcy, your house could be pulled into their situation. And once someone is a co-owner, they can legally sell their share. So before adding anyone to your deed, consider if there's a safer way, like a trust or transfer on death deed, that keeps you in control while still setting things up for the future. Other alternatives are buy-sell agreements and co-ownership. Sometimes you share ownership with someone outside your household. Maybe you own a rental property with your sister or a vacation home with a friend. If something happens to one of you, what happens to your share? Without a written agreement, you could end up co-owning the property with the other person's heirs, meaning you might suddenly have a brand new co-owner you never planned on. That's why many co-owners create a buy-sell agreement, giving the surviving owner the option to purchase the other's share at a fair price. It keeps the property, and your relationship, protected. Another tool some people use is a life estate. That's when you transfer property to someone else, but keep the right to live in it for the rest of your life. It can be a great fit if you want to ensure the next generation receives the home, but still want to live there comfortably. Just remember, once you create a life estate, it's not simple to undo. So be sure you understand what you're giving and keeping before you set one up. Now, let's get practical. If you have additional questions or would like to explore more about real estate in depth, please check out the real estate section in the bonus materials of the My Estate Kit app. And for next steps, for each property you own or co-own, jot down the address, the approximate value, any mortgage balance, who's on the title, or how the property is titled, whether there are any liens or loans attached, and where each property is located. If any are outside your home state, highlight them. That's where ancillary probate could apply. If you're not certain on any of these points, make a note to check the deed or contract. If you can find your deed, great. If not, don't worry. It's part of the public record, and you can always get a copy later. If you're not sure what your property is worth, A quick call to a local real estate agent or looking up recent sales in your area will give you a ballpark figure. Finally, beginning thinking ahead. Would you want the property sold, kept in the family, or gifted to someone specific? This is the foundation for decisions you'll make later about trusts, transfers, and who inherits what, because real estate holds more than financial value. It holds pieces of your life story. And when you take time to plan for how that story continues, who keeps the home, who benefits from its value, or how it transfers smoothly, you give your loved ones a tremendous gift: clarity. You've worked hard for what you have. Now it's time to make sure it continues to serve the people and purposes that matter most to you.